Hi guys, this is CA Balakrishna from Lecturepedia.in. How are you? Hope you people are doing well. Even I am fantastic. Now in this class we will be revising RERA from Paper-6D, Real Estate Regulation and Development Act. I will be trying to complete this video in less than 1 hour time so that it would be useful to revise before the examination. Okay. So now without any waste of time, let us revise. And this notes you can find in our Telegram channel. The link for the Telegram channel I will be giving you in the description. Okay. Now, Real Estate Regulation and Development Act 2016. If you observe 2016, that means before 2016 there is no law regulating the real estate sector. Okay. It was in 2016 for the first time a act to regulate real estate transactions was brought into effect. Now why in 2016 the RERA was implemented? There are many reasons. I will be sharing with you some of the reasons. Now firstly, to regulate the real estate sector. See, if you observe, to regulate stock market transactions we are having SEBI, Securities Exchange Board of India. In the same way, to regulate banking companies we have RBI, to regulate insurance companies we have RERA. But to regulate these real estate transactions there is no authority and no act. So to regulate these real estate transactions RERA was brought into effect. Hope this is clear. This is one of the reason why RERA was brought into effect. Next, dispute resolution. Now before this RERA Act was implemented, in case there are any disputes relating to real estate sector, they will be filed with the civil courts. Now in the civil courts, apart from these disputes, there will be various other disputes, and the time to resolve the disputes in the civil court will be very huge, because apart from these real estate disputes there will be some other disputes pending with the civil court. So under RERA, a separate regulatory mechanism has been established to deal only with disputes of real estate sector. Hope this is clear. Even this is one of the reasons why RERA is implemented. Next, diversion of funds. Generally, before this RERA Act was implemented, the promoters, okay, what the promoters used to do is they used to collect the amount from the allottees, saying that this amount will be utilized for construction of this particular project. And what they used to do is they used to utilize the amount that has been collected from the allottees for construction of some other project. Okay. Now in this case there would be delay in possession or delay in handover of this project actually for which the amount has been collected from the allottees. So to avoid this type of diversion of funds, the RERA Act has been implemented. Now under RERA, the promoter there is an obligation. Whenever he collects amount from the allottees, he needs to deposit that amount. Okay, at least 70% of the amount has to be deposited in a separate escrow account that will be opened specifically that particular project, and the amount from that escrow account should be used only for the construction of that particular project. Okay, by this the diversion of funds will not occur. Okay, even this is one of the reason why RERA is introduced. Next, standardized basis of charging price. See, earlier promoters used to charge amount from the allottees on various basis. Okay, one promoter used to charge the amount based on carpet area. Some other promoter used to charge the amount based on some built up area, and some other promoter used to charge based on super built up area. There was no standard criteria for charging amount from the allottees. So to standardize the charging of amount from the allottees, the RERA says that all the promoters must charge amount from the allottees only based on carpet area. Okay, carpet area has to be used for charging amount from the allottees. Hope this is clear. Next, applicability of RERA. Now applicability of RERA can be seen from three different angles. First of all, geographic wise, it applies to entire India including Jammu and Kashmir. That is the first angle. Next, it is applicable both for plots and apartments. That means plots means there will be a huge open land. Now this open land will be divided into small pieces, and these small pieces known as plots will be sold by the promoter to the allottees. Okay, for such open area which is sold in the form of plots, okay, even for that type of project this RERA will be applicable. On the other hand, construction of apartment and selling the flats in the apartment, even for those types of apartments construction also RERA will be applicable. Hope this is clear. And it will be applicable both for commercial as well as residential transactions. If you are constructing let's say a shopping mall, okay, even for that the RERA will be applicable. On the other hand, if you are constructing some residential houses, even for that the RERA will be applicable. Hope this is clear. That is applicability of RERA. Next, framework of RERA. Now, how the RERA Act is framed? Generally, the central government has developed a model RERA, okay, and based on this model RERA, each state will develop its own state RERA Act. That means every state of India is having its own RERA Act. Hope this is clear. It is not a central act. Each state is having a separate RERA Act. Hope that is clear. Next, there are some frequently used terms in the act. First one is promoter. Who is meant by a promoter? Promoter means a person who is constructing or developing the real estate project. That person will be known as promoter. On the other hand, allottee. Allottee means a person to whom the plot or apartment is sold. Okay, that person will be known as allottee. Now, in relation to allottee, there is one important point that I will share with you. Now, let us say there is a apartment. Okay. Now, this apartment is sold to Mr. X, or this apartment is leased to Mr. X, or this apartment is rented to Mr. X. Okay. Now, in these three cases, in the first two cases, Mr. X will be known as allottee. Okay. But in the third case, where the apartment has been rented to Mr. X, Mr. X is not a allottee. Hope this is clear. This is the first point. Next, now the apartment has been either sold or leased to Mr. X, then Mr. X will be called as a allottee. Now, what Mr. X has done is, this Mr. X further sold apartment to Mr. Y or leased to Mr. Y or rented to Mr. Y. Now, in this case, in the first two scenarios, Mr. Y will also be treated as a allottee. Hope this is clear. And here Mr. Y will not be treated as a allottee. Okay. Here he is not a allottee. Okay. Here the point that you have to be that has to be noted is, if you sell, lease, then that particular person will be known as a allottee. And the allottee, if further sales, leases, even that further person to whom the apartment has been sold or leased will also be treated as a allottee. Hope this is clear. Next. Now, moving into the provisions. Basically, in RERA, we have sections from section 3 to section 9 which specifically deals with various aspects of registration. Okay, section 3 to section 9 deals with registration aspects. Now, registration. What is this concept of registration? Now, every promoter, okay, now let's say there is a particular promoter, okay, promoter. Now, this promoter is constructing some 3 projects, okay, project 1, project 2, project 3, okay, he is constructing these 3 projects. Now, in order to advertise or market these projects, the promoter has to first of all get registration from whom? From RERA. Okay, you are saying that you have to get a registration. Who has to get registration? Either promoter has to obtain registration or the project has to be registered. The answer is project has to be registered. Okay, here since the promoter is constructing 3 projects, each project has to be registered separately. You have to register this project, you have to register this project, you have to register this project. Okay, these 3 projects has to be registered separately with the real estate regulatory authority. Okay, it is not the promoter who has to obtain the registration, it is the project that has to be registered. Hope this is clear. Now let's say these 3 projects promoter is constructing in Andhra Pradesh, and there is one project, project 4. This project the promoter is constructing in Tamil Nadu, then he has to obtain registration for this project 4 in Tamil Nadu, okay, with the Tamil Nadu RERA. Hope this is clear. This is the concept of registration of real estate project. Now in case of new projects, you cannot market or advertise the project without first of all getting that project registered with RERA. What about ongoing projects and COC not obtained? That means this RERA Act has actually come into effect on 1st March 2017. Now for all the projects that are started after 1st March 2017, you will however obtain the registration from RERA. What about the projects which are constructed or which are ongoing before 1st March 2017? Okay, now for the projects which are ongoing as on 1st March 2017 and for which still a completion certificate has not been registered, has not been obtained by the promoter. Okay, for those types of projects you need to obtain registration within 3 months from the commencement of the act. Hope this is clear. Okay, now act has commenced on 1st March 2017. Now before commencement of act, there will be some ongoing projects, okay, not completed projects. If the project is completed before act has come into existence, means you need not obtain registration for that. But there will be projects which are ongoing, still under construction as on date of commencement of the act, and for that projects still completion certificate is not received. In that case, you need to register those projects with RERA within 3 months from the date of commencement of the act. Hope this is clear. The same is I have explained it here, you can go through that. Next, exemption from registration. Now tell me whether all the real estate projects have to get registration or there are any exemptions from getting this registration. The answer is there are certain exemptions. First exemption, let's say the area in which you are developing the apartment does not exceed 500 square meter, or the number of apartments that you are going to construct does not exceed 8. Okay, if any of these condition is satisfied, then you need not obtain registration. Okay, what are the 2 conditions? Area in which you are constructing the apartment does not exceed 500 square meter, or number of apartments, okay, apartments does not exceed 8. Okay, if any of these 2 conditions is satisfied, you need not obtain the registration from RERA. Now the question arises is, what if the area in which you are constructing the apartment is equal to 500 square meters? Even if it is equal to 500 square meters, you need not obtain registration, because he says does not exceed. If it exceeds 500 square meters, then you have to obtain registration. Even in the apartments also, if it exceeds 8, then you have to obtain the registration. Hope this is clear. Next, certificate of commencement received before the act date of commencement of the act. See, this point we have already discussed here. Okay, the act commenced on 1st March 2017. Now before 1st March 2017 you received certificate of commencement, means you need not get registration of that ongoing project. Okay, thereby that is the second exemption. Next, third exemption. Now you are carrying on some renovations or repairs to already constructed project, and such repairs or renovation does not require marketing or any advertisement. Even in that case, you need not obtain registration from RERA. Hope this is clear. Okay, these are the 3 situations in which you need not obtain registration from RERA. Okay, next, application for registration. Now who has to make the application for registration? Promoter has to make the application for registration with whom? With RERA. Okay, now with RERA he will make the application for registration. Along with application, he needs to provide certain details. What are those details? Details of his enterprise and projects launched in the 5 years. Okay, if the promoter is conducting his business in the form of sole proprietorship, then the details regarding the same, or partnership, the details regarding the same, or company, the details regarding the same, along with, in case in the past 5 years if he has constructed any projects, the details relating to those projects should also be submitted. Hope this is clear. Next, certificate of commencement. Now once you started construction of the project, you have to obtain certificate of commencement. Okay, only after obtaining certificate of commencement from the respective local municipal authority you can start construction of the project. Okay, that certificate of commencement should be given to the RERA at the time of obtaining registration, and also sanctioned plan, layout plan, all these documents must also be submitted to RERA as attachments to the registration application. Hope this is clear. Next, project location. Where is the project is located? What is the address of the project? And he should also provide details like what is the area of this project, how many apartments you are going to construct, and in case you have given any subcontract to the contractors, the details of those subcontractors, and what is the time period in which you are going to construct this project. All these details must be given as an attachment to the application. Now as an attachment there is also some important document, that is declaration by the promoter. Okay, declaration by the promoter. What should be declared? See, he should state in the declaration that the land on which the project is being constructed is actually owned by the promoter. Okay, that means the land on which the project is being constructed, the ownership of such land is available with the promoter, or he has legally obtained ownership with some other person. Okay, that has to be declared in the declaration. And such land is free from encumbrances, that means no mortgage is created on that land on which the project is being constructed. That has to be declared. And project completion time period. Okay, within how many years or within how much time you are going to complete this project, that must be declared to the authority, RERA authority, at the time of registration. Why the time period has to be declared? Because the registration will be valid for this period only. Okay, let's say if the promoter says that I will be completing the construction of the project within 3 years, then the registration that is granted by the authority will be valid for 3 years only. Okay, this declaration of completion of the project will be the validity of registration certificate that is granted by the authority. Hope this is clear. Next, deposit 70% amount in a escrow account. Okay, he should also make a declaration to the RERA authority stating that I will deposit 70% of the amount that I have collected from the allottees in a separate escrow account, and I will utilize that amount only for the construction of this particular project. Such declaration has to be given to the RERA authority. Hope this is clear. Next, once such application is made to the RERA authority, the RERA authority within 30 days either accept or reject the application. If it accepts the application, it will give login ID and password to the promoter. Login ID and password related to what? Related to website of the authority. Okay, once the registration is granted to the promoter will get access to the website of the authority. Now in this website, promoter can create his web page. Okay, in this web page he will give details of the project that he is constructing. Okay, so that the public can access those details from the authority's website. Okay, that will happen if the application is accepted. Okay, the registration is granted by the authority. In case the registration is rejected, then the authority must provide what are the reasons why the registration is being rejected, and the authority should also provide an opportunity of being heard to that particular promoter before rejecting the registration. Hope this is clear. Next, what if authority fails to give either approve the registration or reject the registration within 30 days? That means, what if authority does not respond within 30 days? In that case, registration will be deemed to be granted. Okay, if no action in 30 days, deemed to be registered. Okay, in case of deemed registration, the authority will give user ID and password to that promoter within 7 days from the expiry of 30 days. Hope this is clear. Next, validity of the registration. The registration will be valid for the period that has been declared by the promoter in the declaration. Okay, see, time specified in the declaration. Here we have seen this. Okay, for that much of period the registration will be valid. And next, revocation of registration. just a second, I missed a point. Extension of registration. Now what if promoter fails to construct the project within the time period declared? Okay, in the declaration he stated that I will complete the project within a period of 3 years. Now what if promoter fails to complete the project within a period of 3 years? The answer is he can apply for extension, but extension will be granted subject to two conditions. The first condition is the promoter failed to complete the project in the period of 3 years due to force majeure reasons. What is meant by this force majeure reasons? Force majeure reason means those reasons which are not in the hands of promoter. Example, there is a cyclone, okay, or there is a earthquake. Due to that force majeure reason, the promoter was not able to construct the project within the time period declared. Okay, in that case the authority will grant extension, and also that extension can be maximum of 1 year only. Hope this is clear. Next, revocation of registration. Now promoter applied for registration, authority gave the registration. Once the registration is given, whether the authority can revoke the registration, the answer is yes, the authority can revoke the registration if following are found. The promoter contravenes any of the provisions of this act. Okay, if the promoter contravenes any of the provisions of RERA act, then the authority can revoke the registration that has been granted to the promoter, or violates terms and conditions of granting registration. See, authority gave registration to the promoter subject to certain terms and conditions. Okay, now if the promoter fails to satisfy those terms and conditions, then automatically authority will revoke the registration. Okay, next, if promoter involves in any unfair practices or any fraudulent practices, even in that case the authority will revoke the registration. Okay, next, consequences of revocation. Once the authority revokes the registration, what will be the consequences? The first consequence is the promoter will lose access to the website of the authority. Okay, at the time of registration, the authority has given user ID and password to the promoter. That access will be lost to the promoter. That is the first consequence. Next, now the name of the promoter will be included in the list of defaulters. Okay, now on the website of RERA authority there will be a list known as list of defaulters. Now in this list of defaulters, the name of this promoter will be included, and this information will also be communicated to RERAs of other states. Okay, so that if this promoter goes and applies for registration in other state RERAs, those other state RERAs will be cautious while granting the registration to this promoter. Okay, so the information will be communicated with RERAs of other states also. Hope this is clear. See, other state authorities will be informed. Next, bank account of that particular promoter will be freezed, and such other directions as the authority may specify. Okay, those will be the consequences of revocation of registration. Okay, authority has revoked the registration. Now promoter constructing the project, he has constructed, let's say, some 2/3 of the project. Suddenly authority revoked the registration. Now what about this remaining 1/3 of project? Who will construct this 1/3 project? The answer is the authority will appoint such a competent authority to complete the construction of the remaining project, or it will ask the association of allottees themselves to construct the project, or it will prescribe such other manner to complete the remaining construction of the project. Okay, this can happen in case to construct the remaining work. Hope this is clear. Next, now there is a concept of real estate agent. Now basically real estate agent will help the promoter to sell the apartments in his project. That is the work of real estate agent. Now this real estate agent should also get himself registered with authority. Hope this is clear. Okay, registration for real estate agent is also mandatory. Next, functions and duties of promoters. There are some duties of real estate agent that you can go through. Okay, I am not discussing them here. There are certain functions and duties of promoters. What are the functions and duties of promoter? First of all, the first function of the promoter will be to create his web page on the authority's website. Once the registration is granted, he needs to create the web page providing all the information about the project that he is constructing. Okay, next, show website address on advertisement. Okay, now he will be promoting his project through various advertisements and circulars in the newspapers. Now in all those advertisements he must give website address of the authority, okay, where the public can find details of the project. Hope this is clear. Next, share all information with the allottee. See, promoter should not hide any information with the allottee, okay. What are the facilities that the promoter is going to provide to the allottee, and whether the promoter obtained all the required permissions with the relevant authorities or not, and what are the pending approvals that needs to be obtained from the authorities. All these details must be provided to the allottee. There should be nothing that has to be hidden from the allottee. Hope this is clear. Next, obtain all approvals. The promoter must obtain all approvals like certificate of commencement and certificate of completion, okay, and occupancy certificate, like this, and any other relevant approvals that are required. All those approvals must be obtained by the promoter himself. Hope this is clear. Next, promoter should also help in formation of association of allottees, okay. Now once the apartments have been sold to the allottees, there will be various allottees in the to whom the plots or apartments have been allotted. Now the promoter should help in the formation of association of allottees. Hope this is clear. And comply with such other requirements of the act and execute a registered conveyance deed, okay. Now in order to transfer the ownership or the ownership of the apartment from the promoter to the allottee, a registered conveyance deed must be executed, okay. And within 30 days of execution of this registered conveyance deed, all the documents relating to the apartment has to be handed over to the allottee. Hope this is clear. If the respective local law says any prescribed manner to hand over, then you have to hand over in such prescribed manner. If local law is silent, then within 30 days from the date of completion certificate, from the date of possession, you need to give to the allottee the remaining documents. Hope this is clear. Next, note, do not advertise facilities not provided for. See, now you will be providing advertisements relating to promotion of the project. You will be saying that we will be providing these swimming pools, we will be providing gym and various other facilities you advertised, but actually in the project you are not providing all those facilities. In that case, you should not advertise those facilities that you are not providing, okay. You should advertise the facilities only if they are actually providing in the project. Hope this is clear. Do not advertise the facilities that are not actually provided. Next, do not accept any advance without entering into agreement. See, now what the promoters basically will do is, they will accept some advance amount from the allottees. Now the act says that, promoter, you want to accept advance amount from the allottee, okay, you accept, but you first of all enter into a agreement, okay. You enter into a agreement with the allottee, after that you accept the advance, there is no problem, okay. But before entering into the agreement, you should not accept any advance, okay. Promoter says okay. And act also says that after entering into the agreement, the maximum amount of advance that you can accept is 10% of the cost of the project. Hope this is clear, okay. First condition, without entering into agreement you cannot accept any advance, and after entering into agreement also, maximum amount of advance that can be accepted is 10% of the project cost, okay. Next, alteration of sanctioned plan layout to specification. Now the relevant municipal authority has sanctioned the plan of construction, okay, or plan of the layout. Now you are constructing as per that plan or approved plan. Now suddenly you wanted to modify the plan, you want to change the plan, okay. In that case, if the change of plan of construction is relevant to any single apartment, in that case you need to obtain consent of that respective allottee. Hope this is clear. And if the alteration of that apartment is due to some structural reason, okay, if due to structural reason and such alteration is duly verified and approved by authorized architect or engineer, okay, if these conditions are present, then you need not obtain specific approval. It is sufficient if you just give a notice See, if you just give a declaration and intimation to the allottee that we are altering the apartment due to these structural specifications, structural reasons, and the same has been recommended and authorized by architect and engineer also. Okay, like this you have to communicate to the allottee, that is sufficient. Okay, if these condition is present. Hope this is clear. Now, if the alteration of sanction plan is related to common areas or the entire building itself, in that case you have to obtain consent from at least 2/3 of the allottees. Okay, see, common areas or building, written consent from at least 2/3 of the allottees. Hope this is clear. By obtaining consent of the allottees, you can alter it. Next, now you have constructed the project and you have handed over the project to the allottees. After handed over, okay, from the date of possession, okay, from the date of possession by allottee, within 5 years, if at all any defects are brought to the notice of the promoter by the allottee, then there is an obligation on the promoter to correct those defects in the building or apartment. Hope this is clear. See, structural defects brought to the notice of promoter within 5 years of date of possession, the promoter is bound to correct them. Okay, next, transfer of majority rights of project by promoters to third party. See, now what happens is, promoter is constructing the project. He has constructed some half of the project. After constructing half of the project, promoter is not having sufficient amount to construct the project. So what the promoter has done is, promoter wanted to transfer the right on half of the construction of the project to another promoter, so that that other promoter will carry on the balance development work. Okay, now this is what the promoter wants to do. If he wants to do this, he needs to obtain approval of 2/3 of allottees. Okay, hope you understood this. Now let's say, for example, there is a promoter A. Okay, he is constructing a particular project. Okay, he is constructing a particular project. He constructed 50% of the project. Okay, but to construct balance 50%, he is not having amount. Okay, he doesn't have amount to construct this project. So what this promoter A did is, he went to promoter A, promoter B, okay, and asked promoter B that, see, promoter B, I have constructed 50% of this project, still 50% is pending. Now what I will do is, I will sell this entire project to you. Okay, now you construct this remaining portion and you sell to the allottees. Okay, you only give me the amount for this 50%. Okay, balance 50% you incur the amount and you construct it and you sell the apartments. Okay, like this, the promoter A, if promoter A decides to do this, he has to obtain consent of 2/3 of allottees. Okay, only obtaining consent of 2/3 of allottees he can do this. Hope this is clear. Next, that is the first point. Next, transfer of title and other documents to the allottee. We have already discussed this. The title, document and other documents has to be transferred by the promoter to the allottees through registered conveyance deed within 30 days of obtaining certificate of completion. Okay, at the time of starting the construction, you will obtain certificate of commencement. After completion of construction, you will obtain certificate of completion. Okay, now after obtaining certificate of completion, within 30 days you should execute a conveyance deed with the allottee and you should transfer all the documents relating to the apartment to the respective allottee. Okay, or as per the local law. Hope this is clear. Next, what if promoter fails to give possession of the property to the allottee? If he fails to give possession of the property to the allottee within the time specified, then he has to return the amount that has been collected from the allottee along with interest and also compensation. Hope this is clear. Next, composition of real estate regulation authority. Now in case there are any disputes between a promoter and the allottee, they can approach real estate regulation authority. They can file a complaint with RERA. Okay, now here RERA will be adjudicating authority. Now who will be present in RERA? RERA will be having a chairperson and not less than 2 whole time members. Hope this is clear. Now what should be the experience of this chairperson? This chairperson should have experience of at least 20 years in the specified fields. What are these specified fields? There is some list of specified fields given that you can go through. Okay, and the members should have experience of at least 15 years. Hope this is clear. And what will be their tenure? Their tenure will be 5 years or age of 65 years, whichever is earlier. Okay, from the date of appointment they can hold office for 5 years, or if in these 5 years they attains the age of 65 years, okay, whichever is earlier, they have to leave the office. Hope this is clear. Okay, term of 5 years or age of 65 years, whichever is earlier, and they will not be eligible for reappointment. No reappointment after completion of the term. Okay, now whether removal is possible. Okay, after appointing a chairperson or member, whether they can be removed? Yes, they can be removed if following are present. What are they? If that person is insolvent, okay, if he is insolvent, then he will be removed from the office of either chairmanship or the member of the RERA authority, or he has been convicted of an offence involving moral turpitude, okay, he will be removed. Next, he is physically or mentally incapable. Just a second. Yeah, he is physically or mentally incapable. Even in that case, he will be removed. He has acquired some financial interest. Okay, he has become financially interested in that particular entity. Okay, even in that case, that officer or that chairperson will be removed from his office, or he has abused his position. Okay, he has abused his position, and after abusing, if he is allowed to continue the office, then it would be prejudicial to the public interest. Okay, in that case also that person will be removed from the office of chairperson or the member. Hope this is clear. Next, appellate tribunal. Now you went to adjudicating authority, you complained to adjudicating authority. Adjudicating authority given a order. Now you are not satisfied with the order of adjudicating authority, then you can file appeal to the appellate tribunal within 60 days. Okay, so there is appellate tribunal. Now what will be the composition of appellate tribunal? Appellate tribunal will be having a chairperson and not less than 2 whole-time members. Of these 2 whole-time members, at least one must be a judicial member and at least one must be a technical member. Okay, and what will be their tenure? The tenure of chairperson will be 5 years or age of 67 years, whichever is earlier, and tenure of the members will be 5 years or 65 years, whichever is earlier. Hope this is clear. And there will be no reappointment. Okay, now appeals. See, order has been passed by adjudicating authority, that is RERA authority. Now you are not agreed, you are you are not convinced with the order of authority. In that case, you can file appeal with appellate tribunal within 60 days. Okay, appellate tribunal also passed a order. Now again you are not convinced with the order of appellate tribunal, then you can file appeal within 60 days to the High Court. Okay, and High Court will be the final authority with whom the appeal can be filed. Okay, by this almost most of the provisions of RERA I have discussed. Okay, still there are some provisions related to penalty and some miscellaneous provisions. Okay, like accounts, audit, those provisions you can go through. Okay, these are the main provisions from which there is a high chance of asking the questions. Okay, hope this revision was useful to you, and if you wanted to purchase regular classes, you can visit our website lecturepedia.in and you can place your order. Okay, take care, bye bye.